This is a mistake in his view. Let's bring in our legal guys, Avery Friedman, a civil rights attorney and law professor in Cleveland, and Richard Herman, a New York criminal defense attorney and law professor, joining us from Las Vegas. Good to see you both, gentlemen.
Hey, Fred. See ya.
All right, so Avery, you first. The state ordered her to limit her movement, not be within 3 feet of anyone in public. The court ruled. So all of this, was it even necessary? Could this decision or, outcome have been determined without the court's involvement?
Yeah, I mean, it was absolutely unnecessary. All the 3 things that the chief judge decided here, she was doing anyhow. In fact, a reporter said, well, now we're going to pass out candy on Halloween. Actually, my question was, anybody going to show up? But realistically, the idea of quarantining her was not supported by the evidence. Everyone knew it. We're seeing a number of governors around the country, Frederica, ordering quarantines of doctors in hotel rooms. And here we have in KACI HIKOX case. The fact is, unless there's clear and convincing evidence, public health can only be protected with evidence, not with fear.
And then, Richard, Nurse KACI HIKOX, must have, quote unquote, direct active monitoring. But what if she breaks that? Then what?
Well, yeah, if she breaks that, she's going to get arrested, Fred. But here's the situation. These cases are done on a case-by-case basis and on a quick primer in constitutional law. If you're going to limit and restrict someone's individual liberties, the courts do a balancing test, and they have to base it on rational information, and they have to use the least restrictive means. And here, as you read the decision by the judge, he basically said, this is out of fear, this is fear-mongering, this is bad information, bad facts, misconceptions. I'm not going to stand by it. I'm going to use the least restrictive means. But you're right, Fred. If she violates these least restrictive means, she's going to get arrested.
But then that's interesting, too, because you're arresting her, and there's already this, as you mentioned, the judge said, put it, fear or concern about her health and her contact with the public. Then you're going to put her in where if you're fearful of her contact with anybody else. So it seems like, one problem presents another and another. So then I wonder, is this precedent setting at all or influential in any way to other states, Avery, in your view? This predicament and even the outcome?
So. I mean, it's a decision. There's no binding authority. But you know what? It's a 4-pager, not particularly deep. If another judge wants to use it, fine. But it has absolutely no precedential effect.
How do you see it, Richard? Influential?
I agree with Abe. Unfortunately,
You're agreeing?
I have to agree with him on that. For once, he's right. What can I say, Fred? It's a one-state decision. Each state is different, but it's based on it's based on a solid foundation. I think it will be followed.
Okay.